Welcome to the Challa Law weekly webinars. Let's give a few minutes for people to join and then we will get started. I hope everyone had a fruitful weekend and it was restful, and the stress of what's going to happen on the immigration front is, I hope, a bit alleviated. So let's give people a few minutes to kind of join. And for those of you who have been connecting with me every week, I want to thank you for tuning in and spending time with us every Wednesday afternoon. And for those of you who are new, welcome. And if there's any topics you'd like us to cover, please let us know. I mean, it doesn't have to be just what the latest changes are, but it could be, you know, roving employees, issues relating to perhaps the H-1B cap that's coming up, and issues like that. So please let us know, and we would be happy to accommodate, because we're here for you. So let's wait for just another second, and then we'll go ahead and get started. As a lot of you know, immigration is not just, a business for me. It is a passion, and that's partly why we do this. Is we really want to make sure that we get information out. When I was going through the immigration process, believe it or not, I had a really hard time finding out real information. And that was a time where there was no internet or anything like that. So we didn't have resources that sometimes may be true and sometimes may be false. So let's go ahead and get started. Ways to connect. Please, I really would like to connect with you guys in a number of different ways. We use different mediums for transmitting different information. So like us, follow us, share it with your friends. We'd really appreciate it. And if you have happened to miss one of our webinars, it's subscribe to our YouTube channel. Well, where today I'm actually going to be working on a number of small videos that cover like Child Protection Act, or how do you draft a really good job description for a perm, and what are the mechanics behind that, prevailing wage issues. So please join us, subscribe to our YouTube channel, share it with your friends, and if there's any particular topic you would like us to address, let us know, and I'll create a little video where I can walk you through it, because providing information and clarity to you is what we're all about. And if you have any questions at the end, we'll do questions and put them all on the Q&A, please, not on the chat, and we'll take care of the questions at the end. Today, we're going to talk about COVID travel restrictions, essential travel, some of President Biden's priorities, and crafting your immigration strategy for 2021. A lot of great things are in the horizon. Travel restrictions. They're travel restrictions that are not just related to, any type of ban per se, but it's related to the issues that, because of COVID. Although, everyone's trying to get the vaccines out, different countries have varying issues, and now we're seeing different strands of the virus coming out. So many countries have mandatory quarantines and testing requirements, so you should check before you travel. Consulates and embassies are still operating on a limited basis, and it all depends on the country conditions of COVID. There's travel advisories for many countries. India has a level 4 travel advisory, which is do not travel, in effect since August. And on Monday, President Biden signed proclamations to extend the COVID-related travel bans, extended bans on travel from Europe, Brazil, China, and Iran, and added a ban to travel from South Africa effectively January 30th, 2021. And that's to address those new strands that are coming up. It applies to people who are physically present within these countries during the 14-day period preceding the US entry, and it's effective until terminated. I guess it's going to depend on how much we control this outbreak. And this will be evaluated by the Secretary of Health and Human Services every 30 days. CDC announced an order requiring all air passengers arriving to the US from a foreign country to get tested within 3 days of their flight departure, leaving your country. And they should have a result or documentation that they tested negative. CDC also stated that travel should get a viral test, the antigen test, and the passengers, when they're boarding, need to attest to all this information. CDC recommends quarantining 7 to 10 days after travel and avoid people who are at increased risk for illness for at least 14 days. It applies to all passengers 2 years or older, includes US citizens and permanent residents, because remember, this is not an immigration travel ban. This is a travel ban related to COVID. Does not exempt foreign nationals from other restrictions in place, non-immigrant IV restrictions, and does not apply to land border crossings. And it's effective January 26th until 2021. And as I told you, we've got some insight to what's happening within the administration. So we suspect that the proclamation on immigration-related travel bans should be lifted on the 29th of January through an executive order. So stay tuned for that. Additional public health measures, masks are required at all federal properties. That includes interviews, biometrics, any appointments at the USCIS facilities. It's also required on public transportation and interstate travel. And 35 states also require a mask usage in public. USCIS is asking screening questions, including whether any party physically present at the interview has traveled outside the United States for 14 days. And if the answer is yes, they're going to reschedule the interview. And USCIS is also checking CBP records and automatically rescheduling interviews if they've discovered that the applicant has traveled outside. USCIS are also implementing, additional safety measures. You can't enter the building more than 15 minutes before an interview or 30 minutes before an oath interview. You've got to bring your own pens. You have to wear a mask. You can't use the ones with the exhaust valve or bandanas. And maximum attendance is 3 people per interview. So essential travel. There are exceptions. Essential travel, tourism, recreation, gambling, and cultural events are not deemed essential travel. US and Mexico agreed to temporarily limit land border crossings to essential travel. It does not prevent US citizens from returning home, but it remains in effect till February 21st. So for some who want to travel to obtain their visa in Canada or Mexico, that would be prohibited right now. What is essential travel? So citizens and legal permanent residents that are returning to the US, travel for medical purposes, educational institutions, for work in the US, emergency response or public health, individuals that are engaged in lawful cross-border trade, official government, and military these are all deemed essential travel. Does it affect airline travel? It only applies to land, commuter rail, and ferry. Most businesses, business travel and shipments are considered essential. And US, in terms of immigrants that are at the border, they are returning them a rapid return to their existing country if they're entering from Canada or Mexico. the no sail order lifted in favor of conditional sailings for cruise ships. There's going to be a phased resumption of, I don't think I would want to get on a cruise ship until we know that this virus is totally clear. But for those, and they put procedures in place to test the crew members operating on U.S. waters. Biden administration priorities. They wanted to put a halt on removals, deportations, and that has been enjoined by the court, saying that they really can't do that. I think they can probably get away with saying that they're going to reprioritize deportations, and they're prioritizing border safety and enforcements. And they're trying to develop, they're still developing issues related to enforcement policies. The COVID bans have remained in effect, with the NIV and IV bans continue. They're in effect. Remember, President Trump signed it, so they're in effect through March 31st. There's still national interest exceptions and emergency appointments. But like I said, President Biden is expected to sign additional executive orders this Friday. And they're going to try to create a task force to reunify families separated during the Trump administration, and they're going to sign an order to review the public charge rule. If any of you, for all of you who adjusted in October, you can remember that painstaking new form that we've got to file, where you put in like all your financial information for every member of your family. Hopefully this will end that. And President Biden's immigration plan talks about an 8-year path to citizenship for undocumented, if they can pass background checks and pay taxes. They want to change the word alien. So before, there were some, alien was put in place when the INA first was written, and it's been deemed a bit pejorative. And so over the years, the USCIS, in implementing new regulations, has used the word foreign national. One of the things the Trump administration did was strike foreign national in all of the regulations, and where foreign national, they input alien. So that would be addressed. Family-based immigration, they want to clear backlog, recapture unused visas, and eliminate lengthy wait times, and eliminate the 3-year, 10-year bar, which actually makes sense for a number of reasons. But it allows immigrants with approved family-sponsored petitions to join their family in the U.S. on a temporary basis, which makes sense. It is ridiculous that if you are married to a U.S. citizen or green card holder, you have to wait such a long time before you can join your family. So this is very good on so many fronts. They also are going to clear employment-based visa backlogs, recapturing unused, as we talked about, prevent children from aging out, and stimulate economic growth with the pilot program, and improve employment verification process. So there are a number of things that are in place. We're putting together some recommendations to make things easier for our clients and for all of you. So know that we're fighting even on a policy level to make things easier for you. And one of the main reasons why you have a lot of illegal immigration coming in from Central America was during the time when they were able to provide aid. It was economic reasons. And so providing aid to Central America to address some of the underlying causes, they're hoping will deter immigration. So there is a group of people, as I stated, a group of congressional members who are taking the lead on immigration reform. And like I said, I'm very proud to announce that one of our interns is actually staff counsel for one of the main proponents of immigration reform. So, rule to remove H-4 EADs. How long has everybody been struggling with this? So this is been withdrawn. And so H-4 EADs are safe for now. That's great news. So crafting your immigration strategy, what we're going to be doing, like I said, because we're involved with in crafting policies for the administration, is while we're doing that, we're going to tell you what some best practices are for meeting your immigration objectives. And one of the big things I've kept saying is if you have not started your permanent resident process, do it now. This is the time. Because once immigration reform hits, and it's going to take, some time in order to do that, you will want to be, you want to already have an approved I-140. So if you have that, then you'll be able to leverage it, because there will be a time where there's going to be a backlog again. It's just sheer numbers game. So, you want to be able to do that. So now it's time for our Q&A. And I'm going to ask Attorney Challa to hey, Shaker.
Hey, good afternoon, Lakshmi. How's everybody?
And so we're going to do the Q&A process. Remember to join us on our Challa Chats forum. We've got one for H1, H1Bs and one for E3s. I'm sure that my team will send out a link and share it with your friends. Like I said, in the upcoming weeks, we'll have some real critical inside information, and the more we can share it with more people, the more people that can benefit from this process. So send a link to your friends. I said last week, if you can send it to 5 friends, it would be great. So we can get more, I'm using these platforms to also see what are the issues that people are dealing with. So it's helpful on so many different realms. Connect with us on social media in any way you can. And if you want to view the previous webinars, please get on YouTube. And we'll be putting in some new ones this week that discuss just very critical issues. If you don't get a chance to get your question asked, or after the webinar is over, you think of a question you want to ask, email us at info@challalaw.com. The email at info@challalaw.com goes to 3 different people in our firm. So that way, 4 different people. So that way we can make sure that your question gets asked. And like I said, please share the link. It would be greatly appreciated. So, Mr. Challa, we're ready for the questions.
So there's the first question from an AA. How difficult it is to apply green card in EB1A category, and what is the success rate? Do you help in filing GC in this category for a software engineer? And how much experience does your law firm have in this category, and how much support will you be able to give in case I hire you for this?
Well, yeah, and we looked at this the other day. I don't think that we've had an EB1 denied. I think I looked back at least 10 years. And I've been practicing for 25. Our experience, there was a decade where we were special counsel to the Attorney General of Virginia. So we did hundreds and hundreds and hundreds of EB1s, and we do them not only for this, the typical science published type of individuals, but for businesses, for a whole array of different things. So we're very experienced in this, and I will tell you if I look at your resume whether you qualify or not. I don't want to spoil our record of getting these approved, and also I don't want to waste your money. I think one of the things that we do well is we'll say, okay, these are your qualifications so far, and here are the things you need to be doing in order to qualify for an EB1. So I hope that answers your question.
Yep. So, I just wanted to tag on to that and say, for everybody out there, Lakshmi Challa and her team, they're very good at what they do. They have the passion. You need to have a passion to do what you want to do, and that's what they have. And she's been practicing for about 24 years now. So, and she's seen all kinds of cases, and she's, taking care of business in, for all situations. So, not to worry, you're in good hands. So, all right, let's go to the next one. Another AA question. My husband has been approved with his asylum. We got married after the approval of his asylum. He applied for his I-485 back in January 2019. He was called last year, February, for fingerprints. Can he file for my case under Biden administration? And when do we expect the green card arriving? Thank you.
Yeah, I think, there are going to be, especially on the asylum, there's going to be a lot of changes that are taking place within the next couple of months. I mean, they've got some proposals out there and nothing has been solidified. And you should be able to join your husband's adjustment application. If you could email us at info@challalaw.com and just share some details, I can give you some direction on that.
All right. Let's go to Suresh Shastri is asking how Lakshmi and Shekhar Garu, how you guys are doing good. Hope you guys are doing good. Thank you.
Thank you.
My biometrics are done last week for AOS, filed in October, EB2 straight PD September 2010. What is my status if I lose job now as it is not 180 days yet?
Well, you'd have to actually go through, there's no way really to preserve it. If your employer is willing to at least even put you down to part-time status, that's probably a good way to address it until the 180 days has passed. And did your spouse ever file for an I-140, or is it just, are you the only one with an approved I-140?
I got a follow-up something. How long is it taking for getting an EAD after biometrics for the October filers with PD September 2010?
Right. There's still a tremendous delay with biometrics. I think we'll see that speeding up in the upcoming months. But the Trump administration effectively had slowed down all biometrics for the longest time. And now, because there's still limited, appointments that are being made because of COVID, it's going to take some time before they catch up. So, I would say after your biometrics, maybe in about, I would say 8 weeks, you should get your EAD within 8 weeks.
All right. Another question from an AA. Can you elaborate on using EAD for H4 dependent? How does it work on the port of entry?
Well, EAD is not a travel document. EAD is an employment authorization document. So if they've got an H4 visa and they enter, they can work on the EAD. H4s are not an employment-based category, so it's not driven by the employment. They're dependents. So as long as their H-1B is valid, they can enter on an H-4 visa, they can enter on advanced parole, and they can work on their EAD.
Okay. Next question is from Krishna Annapragada. Hi, Lakshmi Garu and Shekhar. How are you all doing? Doing good. Thank you. We have received a EAD AP combo card by last week. Question. My son is 18 years. As of my knowledge, if we are not getting GC before his age of 21 years, he will lose his EAD AP. Is it correct? That's his first question.
Right. So this is one of the YouTube videos that I'm going to put together today on CSP. So Child Protection Act, I don't know if your I-140 is approved or whether you refiled an I-140 pursuant to this adjustment. If you've refiled an I-140 and it's in regular processing, the time the I-140 is pending, your son's age freezes and it gets added back at the time you adjust. The other difference is if you filed based on, so their dates of filing and their, Kara, the two dates, she's going to put it in chat. So there's two types of dates. One is dates for filing and final action dates. Thank you, Kara. So if you filed during a final action date, so it was a final action instead of dates of filing, then, the age freezes. But if it's, if you filed during, if it wasn't a final action date when you filed, and you filed pursuant to dates of filing, then look to the I-140 because if you're filing for dates of filing, it doesn't freeze the age. But if you filed for final action, it does, number one. Number two, the I-140, it depends on how long the I-140 either previously that you filed was pending or that whether you filed again. If you filed again to do a downgrade or something else, that's actually really good. That's what I would have suggested to you to do for anyone that's worried about an age out. And then third, we've got these new regulations that are going to be putting forth some protections for children's aging out. So.
All right. His second question is, if I applied for F1 visa for him, that is a son, after cross 21 years, is it give any problem to him? Because I heard that if students use EAD for his internship programs and change status to F1, should a chance of getting rejection of F1 visa?
No, and your son has some time, so he's 18, 19, 20, 20, you got 3 years. I think you're not going to have to worry about that. I'm pretty sure that there's going to be a fix in the interim.
All right, next question from an AA. Hi, Lakshmi. Thanks very much for your continued support to the community. My 485 application is in process and has been pending more than 180 days with employer A. My I-140 is approved and I have received my EAD AP. I'm located in East Coast now, and can I relocate to another office location in West Coast with the same employer A? Will this move to another office location have any future impact on my GC approval? Do I have to file any additional forms with the USCIS due to this move?
Right, and if I heard correctly, your I-140 is approved and your 485 has been pending for 180 days?
Pending more than 180 days.
Yeah, then you don't have any problem. There's no issue.
All right. Next one from another AA. Thanks for the session. I have applied for OPT STEM extension in December. It's been more than 45 days since the lockbox received the packet.
I know.
I have not received the receipt and my OPT has expired. I'm looking to switch employers and they are asking for the receipt. Please advise about my status, how I can move forward with employers, and what steps USCIS is taking to accommodate F1 OPT students facing delays.
Yeah, so I am alerting the administration to that in an email today. You're not the only one. There's tons of people that are in this situation. And I think the easy fix would be if they temporarily allow, proof of the endorsement on your I-20 and the receipt notice for purposes of employment authorization. So that's what I'm going to recommend. And I just wanted to say, we've got about 40 people on the call today. If you all, as I asked previously, if you could share our webinar information and our Telegram information with at least 5 friends, so we can make sure that we reach more people and we're able to answer more. It would be greatly appreciated. Go ahead, Shaker.
All right. Next one is from Ajay Reddy. He's asking, wanted to check if I can use AVR with valid I-94 BUR expired passport and visa. I don't know what BUR is, I-94 or our expired passport and visa. Probably that's what it is.
AVR, what did he say?
I can use AVR with valid I-94, our expired passport and visa, maybe with our expired.
If you could email me that question, then if I have any additional questions, I can ask you for clarification there, so I don't misspeak.
Okay. AVR, Ajay Reddy says automatic visa revalidation.
Did you travel outside did you travel to Mexico or Canada?
I don't know. He probably is.
And remember now there's
planning
travel,
to Canada. He says planning to Canada.
Right. There's travel restrictions right now, notwithstanding immigration, but through the because of COVID. So, and Canada is very strict about this. So I think both Canada and Mexico came into an agreement with the United States that non-essential travel will not be permitted through the border. So, and if you go to Canada, you're going to have to, and I don't even know if they would allow it. So there's a lot of, if you haven't caught the beginning of our webinar, please do when it's posted, because we go over all those restrictions at the beginning.
Okay. So there's a question on the chat, and I would like all of you to please put your question in the Q&A box. But what I liked just now is when Lakshmi is answering a question and she's looking for a further clarification, I think an answer to that from you in the chat would help, just like as Ajay Reddy did. That was very quick and easy, and that's very convenient for me also to look and see, you know, what the response is. So I'm going to read this question from the chat, but please, fresh questions, put it in the Q&A, please. Hi, Lakshmi Gaurav and Shekhar. Hope you're doing fine by the grace of God. Yes, we are. Thank you.
Thank you.
My daughter's date of birth is October 5th, 2020. October 5th, 2000. I have filed I-485 in December first week of 2020. Do I need to do anything before 5th October 2021?
So you
turning 21 on 5th October.
So this is also an age out question. First of all, I feel like 2000 was just yesterday. I can't believe that's 21 years ago. But what I would suggest to you is, you know, that's not enough information. I need to know if you filed an adjustment, did you file it pursuant to a final action date, or did you pursue it to dates of filing, number one. Number two, if you had an underlying I-140, or you filed a new I-140 as a downgrade, is it still pending, or how long was it pending if you had a previously filed an I-140? And so if I have that information, and it's because we have a lot of questions, you may want to email that to me. And so email at info@challalaw.com.
All right. Arvind Dodapaneni is asking, can I have 3 H1s registered for H1B process 2022 from 3 different employers for H1B lottery?
Yes. The one employer cannot have the same person filing multiple H1B petitions, but the beneficiary can have multiple H1B petitions being processed.
How many? 10,
there is no limit.
15, 20?
There's no limit.
No limit. So if you guys have multiple job offers and all those people are willing to pay for the fees, improve your chances in the lottery, I guess. All right. Next question from AA. I have applied for EB2 to EB3 downgrade and have received the receipts, including for EAD for my spouse. At the same time, we have applied for H4 EAD extension for my spouse. If the AOS EAD comes first instead of H4 EAD, can she continue working using the AOS EAD, as we think the H4 EAD will not come before the current one expires?
Yes,
Thoughts?
again, and the benefit with the adjustment of status EAD is there is a protection within that, just like for an H-1B, where you get, once you file an extension for an EAD, you can work 180 days while it's pending. That's not available for H-4 EADs, and I don't know why they differentiated, but that's another benefit for using the AOS EAD.
Okay, and I think he had tagged on, also in a case where the EB3 I-140 is rejected, what happens to her AOD EAD, which is approved?
Right. So if the adjustment is denied, that's why I always tell people to have a safety net. All the accompanying benefits from that, which is the EAD, AP, would also be denied. But since she has a valid H4, her status won't be impacted. And once the H4 EAD comes in, she'll be able to work on that.
All right. Next one from another AA. Laid off on H-1B visa valid up to August 31st, 2021. I applied for COS to B2 and filed first extension for another 180 days up to June 27. But my I-94 is expired on May 29th, or rather will expire May 29, 21, which was linked to passport validity. Two questions. Do I need to leave the country before this date, even if the decision on B2 is still pending by then? And second, also, if I get a H-1B transfer approved to another employer before May 29th, 21, will I get it with new I-94 date?
Okay, so from the date of termination or when you were laid off, you have a 60-day grace period. Within that grace period, you can change status or find a new H-1B and get that approved. After the 60-day grace period, you can still file for a change of employer, a transfer, but you're not going to get an I-94 attached to it. Even during the 60-day grace period, it is discretionary on part of the USCIS, so you don't even know if that one would get approved. But what you could do is file for a transfer. If you've got a visa, since you've got a valid visa in your passport, you wouldn't have to file for a new visa. You just have to depart the US and re-enter. Now, the trick with that is, because of all these travel bans unrelated to immigration would impact you. So I would take a look at that and use that accordingly. Secondly, you filed a timely extension for change of status. You probably only asked for 6 months, so you would need to depart before that time period, because it, even if it's not adjudicated.
Okay. Next question is from Arvind. He's asking, is there any chance that the biometric process will be fastened now? It's almost 11 months for I-539 approvals.
Yeah, I think they will. I think the other challenge is the COVID challenge, and because a number of offices are operating not at full capacity. So I think eventually it will, but I think it's going to take a couple of months, not only to clear out the backlog, but then to address some of the COVID concerns.
Okay. Next one from an AA, Lakshmi and Shekhar, hope you're all good. You're good. I have filed change of status to F1. During the course of it, does it give me the right to get married?
You can always get married. So that's not going to in any way impact unless you're leaving the country. Now, remember, when you file for change of status, which is different from an extension of status, and you depart the United States, you have deemed to abandon your petition, your change of status petition. So as long as you're not, the marriage doesn't involve you traveling, you can get married here in the United States. That's not a problem.
Good. Next question is from Prem Potter. How long a primary H1 can be out of country with dependent maintaining H4 in US?
Well, is the H-1B still maintained? Is he still working for the employer? Is he going on a visit? As long as the dependence status is dependent on the primary H-1B visa holder. So they have to be in lawful status in order for the dependents to hold that status. So as long as you know, you're on a valid H-1B and you're visiting for pleasure, then that's not a problem.
All right. Suresh Shastri is following up from the previous conversation that we had. Can I stay on bench with the same employer for next 3 months? If employer is okay with it, what is my status if I'm on bench? Or can I transfer to a new employer with H1 and use EAD after 180 days if needed?
Okay, so there are two issues here. Number one, on an H-1B, benching is prohibited. So you can't, even if you agree, even if they agree, you can't be benched and maintain your H-1B status. You can go down to part-time employment, and it can be as little as 10 hours per week, and that's permitted. At least that would keep you in status. If you do change employers before it's 180 days, but you intend to come back and work for your employer that sponsored your green card afterwards, then it's okay. But if you're going to change employers and you're not intending to come back and work for this employer, then you'd have to start your green card process all over again.
Okay, next question from another AA. How much time is it taking for H-1B extension expired in September 2020 now, as I have filed in June but still waiting?
Why don't you upgrade to premium? Because the processing is taking ridiculously long now. So if you can, I would upgrade your petition to premium processing. And you can upgrade at any time. You don't have to just opt for premium processing when you file. You can always upgrade once you've filed.
Krishna is back with a follow-up question about his son who's 18, and he's asking, you asked me about PD, my I-140 in 2012 with premium process that was under EB3.
So did you file for, was it a final action date that you filed, or did you file dates of filing the adjustment?
All right, so we'll wait for the answer from him. Next question is from Nizar. Nizar, dear Lakshmi and Shekhar, thanks for your service. It's really helping every week. If no critical questions are there, could you please take this? February visa bulletin, also no good news for EB3 visa. Do you think people filed 485 during October 2020 will get any positive news before this year end?
Yeah, I mean, like I said, there is a bipartisan effort to, remove the backlogs. If they do, then, everybody that's in the process will all get good news. So it'll be good news for everybody.
Okay. Arvind is back, is asking, what happens if two H1s from two different employers are picked in the lottery?
Then you've got to pick which employer you're going to start working for. And I would pick the one, and we're going to have, probably at the beginning of February, we'll have a special webinar just on H1s. So you want to pick the one that you think is most likely going to be successful. And you don't have to do it while it's in process. You can wait to see which one gets approved and then work for that employer. There is, the cap gap issue. Remember, cap gap is very specific as to how it applies. So if that's going to be an issue with you, then that should help you make the decision.
Okay. Next one is from an AA. I'm currently working for company A and have one more year to max out. Company A is planning to file my perm in future, and there are chances that they may not file at all. There is another company B who's ready to file my perm, future GC, immediately. Will there be a problem if two companies file for perm for the same person?
No. Remember, the company that you're not working for, there is issues of ability to pay. So you just want to make sure that they're able to overcome that, but they can both file. It's not a problem.
All right. Arvind is back with a question. Many people on EADs are losing jobs because of high processing times with USCIS. Why there is not any lawsuit or action like temporary work permit in receipts allowed?
I believe there is a lawsuit in place, but like I said, I'm going to be emailing both the administration and the congressional folks to let them know this is a big issue. So I'm hoping I've got a solution that if they let people work, at least for right now, given the backlog, given COVID, with an endorsed I-120 from their school and a receipt notice for the EAD, that should resolve that problem.
Yeah, he was just emphasizing that almost every family has this issue.
Yeah, no, I get it. I get it.
All right. Next one from another AA. What happens to an already approved GC EAD if the I-140 is denied for a downgrade? If the derivative spouse has already submitted the EAD for I-9, does the EAD get nullified? Note
Yeah,
that
the benefit, yeah, when you file for an adjustment, the EAD and AP are deemed benefits of the adjustment of status. And the adjustment status is only valid with the underlying I-140. Now, if you filed, instead of for your downgrade, if you didn't amend and you filed a new petition for a downgrade, your old petition is still valid. So even if the downgrade is denied, you can, like if you get an RFE, I would go ahead and interfile your, if it's eligible for filing or connecting with the adjustment, that would be something that you would be able to do. So you want to kind of keep an eye on that. And if the numbers become current, and I know it doesn't look so good in February, but I think down the road, with some legislation, that may be the more prudent thing to do.
Okay. I think I was trying to finish off as he says, note that spouse also has a valid H4 status.
So the H4 won't get affected. That's why it's good to have a safety net. But an adjustment needs to be supported by some type of petition, I-140 petition. if the I-140 is denied, the adjustment will be denied. If the adjustment's denied, all the benefits pursuant to the adjustment will be denied.
All right, another question from an AA. Considering that so many I-140 downgrade applications filed during October, do you think the processing time jumps from 6 months to 10 or more months?
Yeah, but I think they're going to address some of the processing times down the road. So it was a big influx, but like I said, I think they're going to try to address some of the backlogs. That is on their radar.
Okay. Another question from an AA. How much time does employer have to reply if there is an RFE for ability to pay for I-140 downgrade application?
What was the question?
How much time does an employer have to reply if there is
Yeah,
an RFE for ability to pay for I-140 downgrade application?
Most RFEs are usually, between 60 days to 90 days. So that's usually the time frame.
So Arvind is back. Says if I-129, 539, and 765 are filed together concurrently, what if we go for stamping outside and revoke I-129 and I-539 application? Can I keep that I-765, or do I need to revoke that also and file another 765?
Yeah, you'll need to file another 765 after you return because it will be deemed abandoned.
Will there be a premium processing allowed for new H1s for 2022?
Yeah, so far we'll have to see what happens once we get closer, but I would imagine that may be hard because technically speaking, just because they get a big influx, but what they've done in the past is they have halted the premium processing for at least like the first couple of weeks, and then they've reinstated it. So they may do something like that. We'll have to wait and see. Keep watching because we'll let you know.
Well, he's also asking what will premium processing happen for 539 and 765? When will it start?
Well, yeah, I mean, they had stated that they would do have a premium processing for 765s, but it wasn't implemented.
Okay. Another question from an AA. When you switch from full-time to part-time in H-1B, what happens to wage agreed originally in the H-1B petition? How long can I stay in US with legal status on part-time job?
You can stay for, you're in valid H status. So, and whatever hours they state, you'd have to file a new LCA, and whatever hours stated on the LCA and I-129, you have to be paid at least that. And so the wages, even though they're calculated annually, they would just, there's also an hourly wage allocated to that. So you would have to be paid the prevailing wage on an hourly basis for the number of hours you've outlined that you would be working.
Okay. Mr. Shastri is back. Just wants to thank you both for the services. Thank you, Suresh.
Yeah, and for all of you who are thanking Shaker and I, it's just not the two of us. I've got this amazing team that works really hard to make sure this is done, especially Kara Wood. So Kara is, not only facilitates this, but also makes sure that the questions get answered. So I would like to thank Kara for all her help in putting this all together, because it really would be very difficult without her.
Yeah. Thank everybody here in this office, the whole team.
Yes.
From front to back, from top to bottom, left to right.
It takes a team, right? It takes a team.
All right, Krishna Annapragada is back. He says, sorry for missed that part This the gentleman with the son from 18 to 21. I filed 485 with 765 I-31 under Table 2, date for filing.
Right. So that means your adjustment doesn't necessarily hold your son's status. So when the priority date, it becomes a final action date, that's when they would review it. You shouldn't have filed your I-140 premium. You should have filed it under regular processing, because that would have given you some buyback time for CSPA purposes. But hopefully the legislation will kick in before your son, he still has some time before he turns 21.
Okay. Next question from an AA. Hi, Lakshmi and Shekhar Garu. Hope you're doing well. I'm on H-1B approved for 3 years. And once I receive my EAD via my spouse application in next couple of months, I switch over to EAD with employer A. Can I go back to my H-1B in future if needed, let's say after 6 months? And
You'd
then
have to file.
do I need to file anything to get back on H-1B that was approved already with the same employer A?
Right. You could always file. So your H-1B, as long as your employer doesn't revoke it, would remain valid. Because you've worked for someone other than your H-1B employer, your H is no longer valid. So you wouldn't be able to port in the United States, but you could depart the United States. And if they have revoked your H-1B, you could file a new H-1B that's not subject to the cap. If your visa is valid, you don't have to get a new visa. You would just re-enter on that. But you wouldn't be able to port because you'd work for someone other than your H-1B employer. I think, Shaker, we probably have time for one more question.
Well, we have quite a few questions that are there. So you want me to look at all the questions or just?
Yeah, because I have a client conference call that's coming up. So.
Okay, so we'll just take Suresh Shastri, and then everybody else. I'm just going to request you to please send your question via email to info@challalaw.com. I apologize. I think by and large, if you can, I think we have this every Wednesday from 12 to 1, and if Lakshmi does not have another appointment, she always spills over for another 5-10 minutes. It looks like not today. So,
and if you send us your questions, what I can do is, and I know we can pull it down, I can make sure that those are some of the things I address next week. So, we'll have some time to talk about it.
All right. So Suresh Shastri, you get the last call. Do you think the backlog will be cleared by this year end with this new administration? Any changes in the USCIS attitude towards the immigrants?
Yeah, you'll see substantial changes for the better. So stay tuned. If you haven't connected with us on Telegram, connect with us on Telegram. Keep continuing to join the webinar so you know what topics that we're going to cover. And if anything, we'll keep you posted. And like I said, we've got some insight into information that we know before it becomes published for everybody else.
So once again, I just want to make sure, if we did not answer your question, I see about 5-6 people. Please send your questions. And there's a suggestion from Nisar. He says, thanks for answering the question. Also, if you do this on Facebook, YouTube Live, more people can benefit out of this.
Okay, yeah. And I was thinking, maybe should I do it on a weekend? Do you think it would be?
Well, the people who are out there, all those who are right now, you can probably weigh in whether a weekend seminar on Facebook, YouTube will be an advantage. You can let us know via email or just put your response in the chat, whichever way
thank
it
you.
works.
Yeah, and thank you for the suggestion. Maybe we'll do that next week. We'll do a FaceTime and YouTube live.
All right. So I think that's it. Since you have another meeting, sorry guys, girls, just send your questions and we'll get the answer today.
Right, and thank you so much for joining us today. Sorry we couldn't we tried to get through as many questions as we possibly could. There were about 53 questions that were asked in total. So email us at info@challalaw.com. Help me out, and like I said, tell your friends, tell your contacts, your coworkers that may be impacted by immigration. I would really appreciate that. I hope you have a fabulous week, and look forward to seeing you again next Wednesday. Thank you, Shaker, for moderating.
Thank you.
Appreciate that, always.
See you soon. Take care.
All right, guys.
See you, everybody.
Bye-bye.
Have a good week.
Thank you.